Hello and welcome to ThePrint. As millions of new investors enter the capital market, a few recent cases, including the Adani-Hindenburg controversy, have brought the spotlight back on the Securities and Exchange Board of India, or SEBI. So in today's episode of Laws of the Land, we'll be talking about this authority. We'll be talking about SEBI, the law that was used to set it up, and its roles and functions today. For this episode, of course, you have me, Apoorva Mandhani. We have with us Bhadra, Sinha, and we have with us Advocate Deepak Joshi, who you've seen on this show before. Thank you so much for joining us
Thanks.
again, Deepak.
Thank you so much, Deepak, and welcome back for the third episode, I think, right?
Yes, thanks.
Okay, so let's start straight away. What exactly is the SEBI Act all about? What does it say? What is the authority that it creates? And then we'll go on to the later questions. So first, what exactly is the SEBI Act?
And why was it introduced as well back in 1992?
Sure. To understand what exactly is SEBI Act and what it says and does, it's important to understand the context in which it was brought into force. Of course, the SEBI Act was brought into force in 1992, but there is a bit of history to that. SEBI as a body was always present since 1988. It was present as an executive arm of the government under the Ministry of Finance. From 1988 onwards, the country was on path to liberalization, opening up and global flow of capital and investments. It also coincided with those reforms of the early 90s which the government took into place. There was an unfortunate scam which happened in the 1992-1993 era, known as Harshad Mehta scam, which actually forced the hand of the government to come up with a statutory body, clothe SEBI with a statutory and autonomous position in law. And it is at that point in time that SEBI Act, first as part of an ordinance, then later as an act, was enacted, and SEBI as an autonomous statutory body was brought into force.
So before it took the shape of a statutory body, what was its role as an executive arm of the government?
To understand that, it is important to understand that
and how did its role change subsequent to the act?
Yes. Pre-liberalization, the role of government executive arms was to regulate and control the use of resources and capital as per the whims of the government, whatever the government found necessary and expedient to do. However, with new money flowing in, foreign investors showing interest in India, that government centric approach had to be shifted to a market centric approach. With that ran the risk of certain gullible investors. The Indian populace was not that well versed with certain market products, which was evident by the way the scam unfolded. So the regulatory powers and the functions were strengthened in the hands of SEBI. They were given a proper staff. They were given proper powers to investigate, adjudicate, and also initiate civil and criminal proceedings. This was earlier not that easy for them to do because they were not an independent body. It had to go through a bureaucratic process under the arm of the Ministry of Finance through the Government of India.
Okay, so what kind of powers does the SEBI law, does this particular law give to SEBI, the statutory body?
Yes, SEBI as a body is very unique in itself. Broadly, it has three sets of powers. One is a quasi judicial power, the other is a quasi legislative power, so to say, and third is of course a quasi executive power. I'll just explain the three of them. The structure of the SEBI Act deals with the primary powers and the functions of the SEBI body. However, the actual implementation has been delegated, and that power has been given to SEBI to formulate certain regulations as to how it wants to implement the functions and the objective of the law on ground. To that extent, it performs a quasi legislative act. It comes up with certain regulations covering wide areas such as mutual funds, investor protection, investor awareness, foreign portfolio investments, insider trading, related party transactions. So these are not framed by the government in the parliament, these are framed by this statutory body. These regulations are then kept on board with the parliament after every 6 months for a formal approval. Now, while implementing these regulations, the SEBI may find that it needs to investigate and adjudicate certain violations. In that capacity, it is the investigator itself. So it's performing the function of an executive body to that extent, because it has its own form of staff and experts looking into the affairs of the company, looking into the price manipulation of security markets, how the stock exchange is controlling or not controlling certain transactions. So that is as far as quasi executive functions are concerned. Now if it has reached a certain adjudication or a conclusion, it then forms an opinion and passes a formal order on itself, which is a quasi judicial function. So that order also has criminal and civil consequences, which of course can be challenged to a subsequent appellate tribunal. But these are the three broad heads under which this SEBI operates and functions. Now of course these have been spread throughout in the structure of the Bare Act, so to say, which is the law as on date. It provides for the constitution of a board, which is of course called the Securities Exchange Board of India, and it has up to a number of 8 members. One is a nominee of the RBI, the others are nominees of the central government, and then one is the heading this board. In discharge of its function as a board, the powers under the Act have been given to make securities which are proposed to be listed on stock exchanges, securities which are already listed on stock exchanges, certain transactions which are not related to stock exchange at all, but they have the color of a public money or public funds being involved. So in those cases, investigation powers have been given, adjudicatory powers have been given, certain officials have been designated to go through the process of investigation. Then very importantly, a special body called the Securities Appellate Tribunal has also been instituted under the Act itself. Originally it was not part of the Act. By way of experience, trials and tribulations, a need was felt. To that extent, the SAT, as we call it, then sits in appeal over the orders, adjudicatory orders, interim orders which have been passed by the members of SEBI against the aggrieved parties. So that's where the supervision and overview check of the impugned orders of the SEBI is conducted.
So does the law, or I'm sure it does, how does it define violation, the SEBI Act, how does it define violations which SEBI board can look into?
Yes. So there is a very
what kind of violations are there? Let us just
correct. So there is a very wide amplitude given under the Act. The language used under section 11 and section 15 onwards, which deals with penalty and adjudication. It says that violation of any provision of law of this Act or regulations framed thereunder. Now it is very important to understand that the SEBI actually operates and clamps down on violations through implementation of the regulations.
Okay.
So you have to then travel to the regulations, which has another set of compliances inbuilt. So for each sectorial participant, it can be an investor, it can be the company concerned itself, it can be a rating agency, it can also be a stock exchange, or it can also be a foreign portfolio investor. If they default on any of the compliances, then depending on the gravity of the compliance and the violation, the SEBI then issues show cause notices, conducts proper hearing, and then passes orders regarding the violation or compliance with regards to the regulations.
So what sort of orders can it pass and what sort of punishments can it give for the violations?
So SEBI has wide powers to issue even protective orders, which are normally ex parte interim orders. So it conducts an investigation unilaterally, and if it sees that there is urgency to pass an order to protect the investors in the meantime without hearing the offending party, it can even issue interim orders, and the nature of those interim orders vary from a normal debit freeze on the banking accounts of the company or the person concerned, to the extent of prohibiting that person from participating in any future security market transactions or not holding the board of a concern or a company in relation to which the violation is alleged. So it's ranges from very mundane stuff to very draconian steps. It can also levy monetary penalty and initiate criminal proceedings. Though that's
Can you just explain criminal proceedings? What kind of criminal proceedings can be initiated?
so that section has been rarely invoked because for that what happens actually is that a violation of SEBI Act is also part of a schedule offence of PMLA.
Okay.
Now these capital offences travel hand in hand under the FEMA Act also. So there they have much stronger powers to initiate criminal proceedings, for which they need to have permission of the concerned magistrate, criminal court. Once the magistrate gives a permission, it then travels through the criminal court procedure and not under the SEBI Act.
Okay, which would be under that particular, it could be under FEMA or
Correct.
it could be under PML.
Correct.
Okay, so you can say that those are the kind of criminal proceedings that get initiated if the SEBI board comes to a conclusion that some sort of criminal investigation is needed or not.
Correct.
Okay, so let us just discuss very briefly, because we are discussing this law in the wake of the, the Adani-Hindenburg controversy. What exactly was the controversy in this case, and the report that was submitted to the court? What kind of recommendations has that committee made to strengthen the entire mechanism of
So the origin of the petitions and the proceedings before the Honorable Supreme Court was in the aftermath of the publication of the report by Hindenburg Group. What had been alleged in that report was that there was certain dressing up of accounts, falsification of books of accounts, which was not actually captured by the Indian regulatory bodies, and also that despite this shortcoming, the share price of the Adani Group shares, which are listed on BSE and NSE, has shot up many folds. So how can that happen? So the report reached a conclusion that this is nothing but manipulation of price by related parties, and those related parties form part of the Adani Group itself through shell entities or opaque structuring on offshore entities. Now because of this report, there was a huge outcry in the public, and the Hindenburg Group had confirmed that on the basis of this study they are shorting the stock of Adani Groups, not directly but through other derivative instruments, because of which there was certain monetary loss caused to the investors in the Adani Group. Now there were 3 or 4 different sets of petitions which travelled to the Supreme Court. Initial bit of course wanted criminal proceedings to be initiated against this group, but the more meatier petitions were actually challenging the inaction of SEBI to have an investigation into these allegations, and also to strike down certain amendments which were done by SEBI as part of its regulations while exercising the quasi legislative powers as being contrary to the object of the law and also helping out the Adani Group in a sense. So this was the meatier petition which was before the Honorable Supreme Court. Now of course the Honorable Supreme Court has delivered a judgment. That is the law of the land. Very minutely what the Supreme Court has said, that it doesn't have the jurisdiction to interfere with the expert opinion of an autonomous body like SEBI.
Means it refused to strike down the amendments as well, which was
Yes.
demanded.
Yes, yes.
Okay.
In fact, the Supreme Court has noted that there is no constitutional challenge to these amendments, merely because there is an apprehension that these amendments favor someone or don't favor someone. That's no ground to strike them down. There has to be a proper constitutional challenge, which is missing in the present
Like
case.
calling them arbitrary or calling them violative of
Correct.
the constitution or something.
Correct.
Right.
And what did the committee suggest, the
Yes.
court-appointed committee?
So the court was faced with a challenge because all of them are judges of no doubt experience, but these are complex structures, complex transactions for which the view of experts are needed. So on the very first day of the hearing, it appointed an expert committee which was independent of the SEBI investigation, which is already going on. The remit of this expert committee was to look into these allegations and the overall functioning of SEBI and give certain suggestions so that it could be improved. Now this expert committee returned with a report. Essentially it stated that there is no wrongdoing on part of the SEBI. The SEBI is going through its regular process which is mentioned under the Act, read with the regulations. However, on the overall structure and as a policy call, certain suggestions were made to improve the functions and the exercise of powers by the SEBI. So, a few of them, the expert committee noted that there is no time limit provided for this investigation, adjudication process to get over, which leads to an uncertain event and also frustration amongst the investors. So, they said that it has to be time bound. The Honorable Supreme Court has directed both the Union of India and SEBI to take into consideration this recommendation and come up with certain developments.
Right. So, you know, in response to these petitions filed in the Supreme Court, SEBI had actually spoken about the line of its investigation, but it had, also added about the limitations of its investigation vis-a-vis two particular instances, because it said these are offshore companies and we are waiting for responses, from there. So, what do you have to say about this aspect of the probe, in the sense that, if they never receive, if SEBI never, this can happen in any case. I'm not specifically talking about this case, but this blockage, which we can say, can arise in any case where a foreign country may not be willing to share information with SEBI. Then what really happens? Do the regulations deal with this kind of a situation?
So, the regulations are only affirmative to the extent that they can call for the information to know the beneficial ownership or the identity of an investor, but it doesn't mandate that the SEBI has the power to definitely execute that calling of the information.
Okay.
So, if due to the municipal laws of a foreign jurisdiction, it becomes easy for the foreign jurisdiction and the authorities there to avoid giving this information, I am afraid SEBI as of today doesn't have much powers under the SEBI Act. However, similar problem is there in other allied laws also, vis-a-vis Income Tax Act, FEMA, PMLA Act, and these problems are resolved not at the level of statutory or autonomous body functioning, but at the level of bilateral treaties and exchange of information. It has happened in past with Switzerland also in certain tax cases. So, I have no doubts that it can also happen at a government level through these bilateral exchange of information or a bilateral treaty to that effect.
So, to that extent, do you think that the powers that SEBI has right now, there needs to be a relook or a sort of an overhaul in a way that could help maybe better probe of such instances or cases?
It should. It's a developing act. In fact, there have been 5 amendments in the first 5 years when the law came into being. So, I'm sure as and when the law catches up with certain loopholes, there will be more amendments. However, it will be tough to expect SEBI to exercise jurisdiction outside the country. That may have other challenges under the constitution as being extraterritorial applicability of the law. That may be a shadow of doubt over such powers.
Okay.
With that, we've reached the end of this episode. In this episode, we spoke to you about SEBI as an authority, its role, why was it brought in the first place, and what is the sort of authority that it has to probe cases and to protect investors. I hope you enjoyed the episode. Thank you so much for watching.